Before we begin, 95% of our viewers do not subscribe. So please click that subscribe button. It will help our channel reach more audience. All right, so you want a clear breakdown of the Employee Rights Act, or ERA for short. It's been making waves. Strong opinions on both sides. We've got a stack of articles and reports right here ready to sift through and get to the heart of the matter.
It is remarkable. We're potentially looking at the biggest overhaul of labor laws since 1947. I mean, the rules that govern our workplaces, they've essentially remained unchanged since the post-World War II era. Can you believe that?
Yeah.
This bill, H.R. 2700, it aims to bring those rules into the 21st century.
And the person who introduced it, Rep. Rig Allen, it's a pretty interesting background. He's a Republican from Georgia. He actually built his own construction company. So he's coming at this with a business owner's perspective, which adds another layer to the whole story.
Absolutely. That context is crucial. The bill itself, it dives into some pretty intricate areas, like how unions are formed, how they can use their members' dues, and even the very definition of an employee versus an independent contractor. These are all hot-button issues with far-reaching implications.
One of the biggest flashpoints is this whole idea of secret ballot elections for unionization. The ERA is really pushing for this, moving away from those card check campaigns where unions gather signatures to demonstrate support. Instead, any decision about forming a union would have to go through a private, anonymous vote. It's like choosing a political representative, but for your workplace.
That's a great analogy. And it highlights the core argument here, worker freedom. Groups like the Competitive Enterprise Institute and the U.S. Chamber of Commerce are strong advocates for secret ballots. They argue that open card checks, those can create an environment of pressure, even intimidation, making it difficult for workers to express their true opinions. A secret ballot levels the playing field, ensures that everyone can vote their conscience without fear of reprisal.
But hold on. There's a whole other side to this story. Labor unions and some worker advocacy groups are pushing back hard against this secret ballot idea, saying it throws up a major roadblock to organizing, weakens workers' collective bargaining power. It's a classic tug-of-war between individual choice and collective action, a question that goes way beyond just unions.
Exactly. Think about it. Our economy has transformed dramatically. We've got the gig economy, remote work, all sorts of new employment models emerging. This bill seems to be grappling with how to adapt those old 1947 rules to this new reality, which is no easy feat.
Another point that really jumps out is how the ERA wants to change the rules around union dues. Right now, unions have a fair amount of flexibility in how they use that money, but this bill would require them to get explicit permission from each member before using those dues for anything beyond direct collective bargaining. Things like political contributions would need a thumbs up from each individual worker.
And that's a seismic shift. We're talking about potentially millions of dollars that flow from union coffers into political campaigns and causes. This provision could fundamentally reshape the landscape of political spending and influence. And it's unsurprisingly generated a lot of controversy.
It's a clear example of how this bill is trying to rebalance power dynamics in the workplace.
Yeah.
And it doesn't stop there. It also digs into the whole issue of who gets classified as an employee versus an independent contractor. A line that's become increasingly blurry, especially with the rise of companies like Uber and DoorDash.
Right. The ERA proposes using a common law definition, which focuses on how much control and independence the worker actually has. Supporters argue this will provide clarity for businesses navigating the complexities of modern work arrangements, but critics worry that it could lead to workers being misclassified as independent contractors, potentially denying them benefits they would be entitled to as employees.
It's a bit like trying to fit square pegs into round holes, figuring out how these traditional categories apply in a world where work is constantly evolving.
Precisely. And the ERA doesn't stop there. It goes a step further by incorporating something called the Save Local Business Act. This aims to shield businesses, particularly franchises, from being held liable for the labor practices of other companies they might be connected to.
Essentially, it's about trying to define clearer lines of responsibility in a world where business relationships are becoming increasingly interconnected.
Exactly. It's a direct response to concerns from franchise owners, who are worried about being unfairly penalized for actions that are outside their control. This is yet another way the ERA is attempting to reshape the landscape of employer-employee relations.
It's important to note that all of this is still very much up in the air. The bill, H.R. 2700, has been stalled in Congress since March of 2023. It's clear that this is a complex and contentious issue with no easy answers.
It really begs the question, why the standstill? Is it purely political gridlock? Or are there deeper concerns about the bill's potential impact that are causing lawmakers to hesitate?
It makes you wonder what's happening behind the scenes. What kind of lobbying efforts are underway? What compromises, if any, are being considered?
It's like a high-stakes chess match, with each side trying to anticipate the other's moves and protect their interests. And in the middle of it all, you've got millions of workers whose lives could be directly affected by the outcome.
And the ERA doesn't stop there. It also wades into the complex issue of tribal sovereignty, specifically exempting Native American tribes and their businesses on tribal lands from the jurisdiction of the National Labor Relations Board.
Now, this is where things get particularly interesting, because it touches on the delicate legal relationship between tribal governments and the federal government. Supporters argue it's a matter of self-determination, recognizing the inherent right of tribes to govern their own internal affairs.
But opponents of the ERA view this provision as yet another way. The bill tilts the scales in favor of employers. They argue that it could potentially leave tribal employees with fewer legal protections and recourse if labor disputes arise.
And it's not just about the specific provisions themselves, but about the broader message they send. Critics see this as part of a larger trend of eroding worker rights and empowering corporations, a move they believe undermines decades of progress in strengthening labor protections.
On the flip side, supporters of the ERA see it as a necessary course correction, a way to modernize labor laws and adapt them to the realities of a rapidly evolving economy.
It's clear that both sides have compelling arguments, and the debate is far from over. It'll be fascinating to see how this all plays out in the coming months and years.
There's so much more to explore here, and we'll continue our breakdown right after this.
Welcome back. As we delve deeper into the ERA, it's important to remember that we're dealing with a complex web of perspectives. While it's easy to get lost in the legal jargon and political maneuvering, at the heart of this are real people whose lives and livelihoods are at stake.
That's a really important point. It's easy to lose sight of the human impact when we're talking about laws and regulations. But ultimately, every decision made about labor laws, it has a ripple effect that touches workers, employers, and entire communities.
Absolutely. And that's why it's crucial to look beyond the headlines, really understand the nuances. Take the debate about secret ballot elections, for example. It's not just an abstract argument about voting procedures. It's about whether workers feel safe and empowered to express their true preferences without fear of retaliation.
And that sense of empowerment, or the lack of it, it can have a huge impact on the workplace. It can affect morale, productivity, even the overall culture of a company.
Precisely. And that's why the ERA is generating so much heat. It touches on some fundamental questions about power, fairness, and the role of unions in a modern economy. These are questions that have been debated for generations, and there are no easy answers.
Speaking of unions, it's worth remembering that organized labor has a long and complicated history in this country. Unions have played a pivotal role in fighting for worker rights, improving working conditions. But they've also faced criticism and challenges along the way.
Right. And the ERA seems to reflect some of those evolving attitudes towards unions. There's a definite emphasis on individual worker choice and a move to curtail the influence of unions in certain areas.
That provision about requiring individual consent before using dues for anything other than direct collective bargaining is a prime example. It seems to suggest a certain level of distrust in how unions manage their finances and make decisions.
It also reflects a broader societal trend of questioning the power of collective action versus individual rights. It's a tension that plays out in many areas of our lives, not just labor relations.
Now let's shift gears for a moment, talk about how the ERA tackles the definitions of employee and independent contractor. This has become a real headache in recent years with the rise of the gig economy and the blurring of traditional employment boundaries.
And it's not just about semantics. It's about access to benefits, social safety nets, and even fundamental rights. If someone is misclassified as an independent contractor when they should legally be considered an employee, they could be denied things like minimum wage, overtime pay, and unemployment insurance.
That's why getting these definitions right is so important. It's about ensuring fairness, protecting workers, while also allowing businesses to operate within a clear legal framework.
And this is where things get tricky, because there are valid arguments on both sides. Some businesses argue that existing labor laws are too rigid and don't account for the flexibility and innovation that characterize the gig economy.
They say that being forced to classify all gig workers as employees could stifle entrepreneurship and limit worker choice. There's a fear that it could actually harm the very people it's intended to help.
On the other hand, worker advocates argue that this is about preventing exploitation, ensuring a basic level of fairness. They point out that many gig workers are essentially employees in all but name, and they deserve the same protections and benefits as traditional workers.
So it seems we're stuck between a rock and a hard place. How do we find a solution that balances the needs of both workers and businesses in this rapidly changing landscape?
That's the million-dollar question. There's no easy answer. And it's going to require a willingness to compromise, adapt, and think creatively.
And that brings us back to the ERA. Whether you agree with all of its specific provisions or not, it's undeniably a major attempt to address these complex and evolving dynamics in the workplace.
It has certainly sparked a national conversation about what labor laws should look like in the 21st century, and that in itself is a valuable outcome.
It's like we're at a crossroads, trying to figure out how to navigate this new terrain and create a system that works for everyone. It really feels like we're in uncharted territory here, trying to find that sweet spot between protecting workers and fostering a dynamic economy. It's a delicate balancing act.
Absolutely, and that's what makes this whole discussion so crucial. There are no simple solutions. Any path we choose will likely have trade-offs. That's why it's so important for everyone to be well-informed about the issues at play. Regardless of their political leanings, the ERA is a multifaceted piece of legislation. It's essential to understand the nuances and the potential ripple effects it could have.
It's not about blindly supporting or opposing a bill, right?
Yeah.
It's about engaging in thoughtful and informed discussions about the future of work and how we can create a system that is fair and beneficial for everyone involved.
Exactly. We need to move beyond partisan divides and really grapple with the core questions. How do we ensure that workers have a voice and are treated fairly, while also fostering an environment where businesses can thrive and innovate? These are questions that affect all of us. And the more informed we are, the better equipped we'll be to shape a future of work that benefits everyone.
So where does all this leave you, the listener? That's the question we always want to come back to. The ERA has the potential to significantly reshape the relationship between employers, employees, and unions. It's a potential turning point in how we think about work and labor relations.
Regardless of your personal stance on the ERA, understanding the key elements of this bill is crucial. It could directly impact your workplace, your rights, and your livelihood. Knowledge is power, as they say.
We've given you a solid breakdown of the ERA, but we encourage you to dig deeper. Read the full text of the bill yourself. Explore different perspectives and analyses from experts and organizations. Form your own informed opinion, because ultimately these are decisions that will shape the future of work for all of us.
It's a collective responsibility. The more engaged and informed we are as citizens, the better the outcomes will be for everyone.
Please like and subscribe. It will help our channel.